We have breaking news that was a couple days ago, but I wasn't able to shoot this video. I want to talk about the Coons case out of the state of New Jersey, specifically the 3-judge panel by the Third Circuit Court of Appeals that partially stayed, which means pause or freeze, the order in our favor, meaning in favor of the Second Amendment by Judge Bumb in the challenge to a whole swath of New Jersey's carry laws. So let's talk about this when we get back. I'll tell you about my thoughts on the panel and the decision. Let's chat. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. And of course, make sure you follow me on Twitter if you're on Twitter, at 4 Boxes Diner. All right, folks. Yeah, a couple days late on this. It's my fault. I'm not going to be late anymore. I had a few crazy days of travel and whatnot, but the good news is we should be back and rolling again. So with that said, the decision by the Third Circuit Court of Appeals 3-judge panel, this is an administrative panel. So let me tell you what they decided. Let me tell you about the panel, and let me tell you about where we're going forward in New Jersey and in the Third Circuit Court of Appeals. So first of all, as you recall, Judge Bumb, a district court judge in the District of New Jersey, entered a very broad preliminary injunction, enjoining, which means putting on pause or freezing, a large number of laws enacted by the state of New Jersey in response to Bruin to try to make it harder to carry guns. So even though you could get a concealed carry permit easier in some respects in New Jersey after Bruin, which obviously you should, they try to create what I predicted, which is what happened, to try to create most of the state of New Jersey as a quote-unquote sensitive place, which is a euphemism for a government-mandated gun-free zone. And Judge Bumb came in and entered an order that declared much, not all, but much, of those sensitive places laws and some other related issues to be unconstitutional under the Second Amendment. She entered what's known as a preliminary injunction, which meant that from the time of that day where she entered the preliminary injunction through the end of the case, those laws enacted by the state of New Jersey involving carrying guns in that state would not be enforceable. They would be frozen or enjoined with a preliminary injunction. The state of New Jersey took an emergency appeal to the Third Circuit Court of Appeals, which is the federal court of appeals that oversees Pennsylvania, New Jersey, and Delaware. And because it was an emergency appeal, they got an administrative panel. Now, this is important to understand. The administrative panel is the panel that handles emergency appeals seeking emergency relief. Here, because New Jersey sought an emergency stay, which means a pause, on the effect of Judge Bumb's order enjoining all the New Jersey laws, or the vast majority of them involving carrying guns and the sensitive places issues. New Jersey sought an emergency stay of Judge Bumb's lower court ruling. As I've mentioned in other videos, when you have an emergency request for relief to courts of appeals or the U.S. Supreme Court, usually there is a judge or a group of judges, a panel of judges in the Court of Appeals that are sort of standing by in a way, sort of a little bit like a doctor on call in an emergency room or a veterinarian clinic where everyone goes home for the holidays, but there's one veterinarian that kind of stays behind. So if there's an emergency, there's someone there to handle it. So the Third Circuit had this arrangement, and when New Jersey sought this emergency stay of the Judge Bumb order, it was assigned to a 3-judge panel, which is an administrative panel. It doesn't, and this is what's important, it does not necessarily mean that these 3 judges I'm about to describe are the 3 judges that are ultimately going to make a decision on the merits and write an opinion on whether or not Judge Bumb's lower court preliminary injunction should be upheld in all or in part or not at all. So this 3-judge panel consisted of 3 judges. It was actually a very, very bad panel for the Second Amendment as I see it. Specifically, the 3 judges was Judge Cheryl Ann Krause, an Obama appointee, She is terrible on the Second Amendment. In the Range case recently decided, which was a very good decision for us, dealing with nonviolent felons and the ability for them to have their gun rights back after they've served their sentence, Judge Krause rejected the historical arguments and basically said that the government gets to dictate who can have a gun and who doesn't. They get to tell you whether or not if they view a trespasser or a jaywalker or someone that doesn't recycle trash to be not virtuous, or someone who's not respectful of the rule of law, and thus they can be denied their gun rights forever. Well, that is Judge Krause's essential view, an Obama judge, no good on the Second Amendment, and she was on this panel. Needless to say, she voted to stay a large chunk of the lower court order. But there's some very good news here in a second I'll get to. The other judge ruled in our favor, Judge David Porter. He's a Trump judge. He specifically stated that if he were deciding this by himself, he would have upheld the entirety of Judge Bumb lower court preliminary injunction. So that's a very good outcome. He basically says that he thought Judge Bumb got it completely right and wouldn't have changed a thing. So he dissented essentially from this 2-1 ruling, in largely against the Second Amendment, though not entirely. We'll get to that in a second. Now, the third judge is interesting. The third judge is the newest judge on the Third Circuit. This is Cindy Chung. She's a graduate of Yale. She is a recent Joe Biden pick to the Third Circuit. She spent almost her entire career, if not her entire career, working for government, the Department of Justice, and other government-related entities like this. So basically, she went from law school to government work, clerk for a year, which is fine. A lot of people do it. I did that. It's a very prestigious thing. You do it for a year. But she, instead of going into private practice, she went and continued on and spent her career in government. And now she's a government judge. So that's Judge Chung, Cindy Chung. And she, of course, being a Biden pick, went along with Judge Krause and 2-1 ruled that a lot of Judge Bumb's rulings in favor of the Second Amendment would not be allowed to go forward. They would be stayed pending the ultimate decision by a 3-judge merits panel, which could be these 3 judges, Judge Krause, Judge Chung, and Judge Porter, but it doesn't necessarily have to be, and I actually don't think it will be this panel. I think it will be a different panel. I don't think, for example, that Judge Chung is going to be on the merits-based panel when we get there. So I don't think this is going to be the panel, but anything's possible. All right, so that's kind of the lay of the land. Now, what did this 2-1 ruling do? Well, it cut back materially, largely, of Judge Bumb's order in our favor. Specifically, what it did. Now, but here's the interesting thing: it only did it in part, which is very interesting. So we had a terrible Second Amendment panel, right? 3 of these judges, one of whom was pro-Second Amendment, a Trump judge who would have upheld Judge Bumb's lower court rulings. 2 of which, Biden and Obama. This is obviously not, as a general matter, a good panel for the Second Amendment. As I see it, nevertheless, we won quite a bit of good stuff, which is kind of shocking if you think about it, because I would have predicted that with this 2-1 panel with Judge Krause and Judge Chung in the majority, they would have wiped out all of Judge Bumb's excellent work on the grounds that they don't want guns, they don't like guns, that kind of stuff. But they didn't do it, which I think bodes well for a big part of the, where Judge Bumb's going, that you have a terrible Second Amendment panel still supports Judge Bumb in support of the Second Amendment in many respects. But let's go specifically what this 2-1 decision says, and then we're going to talk about what will happen next. Specifically, as you recall, this was all about what quote-unquote sensitive places the state of New Jersey declared to be gun-free zones, and then again, Judge Bumb says a lot of this stuff is not historically supported. As you recall, you look at the text of the Second Amendment, obviously where you can carry a gun implicates the right to bear arms, which means the right to carry guns outside in public. So then the question is, what is the historical tradition of firearm regulations with actual laws in the book at the time of our founding? The reason why 1791, the time of the founding, is the critical time period for understanding the meaning of the Second Amendment is because in 1791, you look to what the people who ratified and supported the Second Amendment and wrote the Second Amendment at the time understood the Second Amendment to protect, and that's why you laser focus at that time period as opposed to, let's say, 100 years later in the late 19th century when all the founding fathers involved with the creation of the Second Amendment are dead. Right? So it's a different group of people. Their intent would be irrelevant as to what happened in 1791 because they weren't around. Okay, so with that said, the three-judge panel did not issue any kind of a opinion, no explanation of anything other than Judge Porter saying that he would have supported Judge Bumb's ruling in its entirety, but he was in the minority, so he lost 2-1. But these are the sensitive places that are now, quote-unquote, sensitive places yet again. Specifically, the Third Circuit panel says that the rule that says you can't have a gun within 100 feet of a place of a public gathering, demonstration, or event is held for which government permit is required. During the conduct of such gathering, demonstration, or event, you can't have a gun there. Well, they stayed Judge Bumb's ruling that says that is unconstitutional. Likewise, when it comes to zoos, they also said that no, you can ban guns at zoos. I don't know where they get the historical tradition from that. They're obviously just making it up as they go because there is no such thing in that respect. They also say that you can prohibit carrying guns at a nursery school, preschool, or summer camp. But those three issues were not challenged, so there was not really enjoined in the first place. So just keep that in mind. You can't have a gun in nursery school, preschool, summer camp, or at zoos. The other thing this 2-1 decision did is they reaffirmed and said that the following is a sensitive place. Again, Judge Bumb says it wasn't a sensitive place, but the three-judge panel 2-1 says it is, specifically a park, beach, recreation facility, or area or playground owned or controlled by the state, county, or local government unit, or any part of such place which is designated as a gun-free zone by the governing authority based on considerations of public safety. Bing, 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 bing. You can't do that, right? You see what I'm saying? Here we are. The state is talking about public safety. But as you know, black letter Supreme Court precedent says you can't consider this sort of interest balancing. Nevertheless, this 2-1 decision by the Third Circuit basically said that indeed parks, beaches, recreation facilities, playgrounds, or any of these things owned or controlled by the state, or can basically, they can ban guns in these locations. That is not a violation of the Second Amendment. Again, this is the 2-1 emergency panel that said that. The other thing is they said they can, yes, the gun bans for publicly owned or leased libraries or museums. There's clearly no precedent at the time of the founding for banning guns in libraries or museums or places of work. Keep in mind that I believe the Library of Congress itself actually came and was created because of the acquisition, I can't remember if it was through donation or purchase, of all the books of Thomas Jefferson and Madison. They were huge readers. They had massive private libraries. All the founding fathers did, and I can assure you when they hung out at their private libraries and talked about books and Caesar Beccaria and the like at the time of the founding, they all had their guns nearby. Nevertheless, here you have a 2-1 decision against us. Not going to stand up, I don't think, in the long run, but in the short run, this 2-1 decision says, indeed, you can't have guns in a publicly owned or leased museum or library. They said that if a bar or restaurant where alcohol is served and any other site or facility where alcohol is sold for consumption on the premises, those can be gun-free zones. They overruled Judge Bumb. Again, this is, of course, completely stupid. If you just think of all these sort of chain restaurants, the Chili's of the world, the Applebee's of the world, Greek diners in the Northeast, these kind of basic places, right? They technically all can serve alcohol. Now, I've been in plenty of Greek diners in New York City. I don't think I've ever had any alcohol in a Greek diner ever. Nevertheless, technically speaking, for example, because they have most of them have liquor licenses and therefore they can legally sell alcohol. Technically speaking, you would no longer be able to have a gun in these places under this New Jersey law, even if you're not drinking yourself, which of course is absurd. And we know that at the time of the founding, people like Samuel Adams literally created the American Revolution in taverns where people drank and talked about revolution. Obviously, there was no gun bans in these places because that's where the American Revolution started. Nevertheless, this 2-1 decision said indeed it is a sensitive place, and they upheld it. The next thing is they said that it's also brought back a sensitive place, overruling Judge Bumb again. If it's a privately or publicly owned or operated entertainment facility, this includes theaters, stadiums, museums, arenas, racetracks, and other places where concerts and the like are performed. So that means you can't bring it to a movie theater, apparently. So, well, you're defenseless there. That's clearly no precedent at all for this sort of thing. Nevertheless, this 2-1 decision by Judge Chung and Judge Krause against Judge Porter basically, said that Judge Bumb Bumb got it wrong, but clearly Judge Bumb's got it right. Keep in mind, I want you all to be optimistic about what's going to happen here in the Third Circuit, because remember, the Third Circuit en banc, the range case dealing with nonviolent felons, and we had a very big victory there. So if the 3-judge merits panel, whoever they may be, screws this up, watch very carefully. You may see an en banc Third Circuit review in our favor, because that's not a bad court when it comes to the Second Amendment. They take it pretty seriously. Also, they've overruled Judge Bumb, said that the law that says you can't have guns at casinos and related facilities, including but not limited to the related restaurants, bar facilities, and retail establishments, and so on. You can't have guns there. They brought that law back. They also brought back the law involving you can't have guns at healthcare facilities, including but not limited to various forms of hospitals and the like. A whole list of these things. That was all there. So all that stuff, Judge Bumb said, was not a sensitive place under the Second Amendment. All those things I just described, the 2-1 decision by the Third Circuit Emergency Panel said that indeed they can be sensitive places for now, and have effectively stayed Judge Bumb's favorable ruling, putting us back to ground zero to some degree. But again, we'll see what the merits panel says. But there is some very good news here. This is very good news. This is a loss. I'm not happy about it. I think it's all going to work out in the end in our favor in the Third Circuit. But this is a loss. I'm not going to lie to you, but it's a loss of a battle and not a war. We're going to have some setbacks. We're going to lose some battles, but we're going to win this war for our Second Amendment rights. In fact, again, we don't have to win the war for the Second Amendment. We've already done it. It's in the Bill of Rights. It's in the Constitution. What I'm talking about when I refer to the war involving the Second Amendment, I'm talking about the restoration of the right to keep and bear arms all across America, including in those rogue blue states that simply hate the fact that Americans are citizens and not serfs or subjects, or even worse. Okay, now let's talk about specifically some of the good news from this 2-1 decision, specifically the 2-1 panel. Judge Krause, terrible on the Second Amendment. Judge Chung, and a Biden appointee, not much of a record, but basically spent her life working for government. Probably a pretty good sign that she's happy with government having guns and not you having guns. That's why Biden probably picked her. Nevertheless, 2-1. They did rule in our favor, meaning they supported Judge Bumb's ruling that some of these things are indeed not sensitive places, cannot ban guns under the Constitution. The first is public locations being used for the making of movies or television images for theatrical, commercial, or educational purposes during the time such location is being used for that purpose. That's number one. Number two, and this is a very big one. This is called the default property rule. As I've talked to you before, one of the things the anti-gunners made up a few years ago with some academics that the judges are trying to bring around and the anti-gun legislators are trying to embrace is to say that you can't bring a gun anywhere on private property in a particular state unless you first get consent from the private property owner. But the practical reality is that means you can't carry a gun anywhere, because I have no idea when I stop at a gas station, when I stop at a restaurant, when I stop at a bookstore, I have no idea or I go into a building, I have no idea who the owners are. There's no way to contact the owners. You don't even know what consent would consist of. So basically, you prevent people from being able to carry guns, because there's no way for them to practically get consent from the owners of these facilities. Because you go to one, gas station one time, on the highway, you have no idea who owns these places. There's no way to even figure it out. And that's one of the new strategies the anti-gunners brought about a few years ago. New Jersey tried it, but the good news is this 2-1 panel with 2 judges, including 2 anti-gun liberals, as I see it, that seems to be the evidence. They actually said no to New Jersey, that you can't have a law that says that you're not allowed to bring guns on private property that's open to the public without first getting consent. So that's very good news. Specifically, the part of the law that has been enjoined by Judge Bumb that was upheld by this 2-1 panel is the law that says you can't have a gun on, quote, private property, including but not limited to residential, commercial, industrial, agricultural, institutional, or undeveloped, et cetera, et cetera, et cetera. Y'all, kind of put a link to this law down below. I think it's section A24. Part of that law was enjoined by Judge Bumb. This 2-1 panel actually came up and affirmed Judge Bumb, which is a very good sign that you have what appear to be very anti-gun, pro-government judges are still ruling in favor of the Second Amendment to a large degree, although not perfectly. It's certainly better than we were like 2 years ago, let's say. The other thing is that the 2-judge panel came out and said that the prohibition on having functional firearms in vehicles, unconstitutional. The Judge Bumb said that was not allowed, and this 2-1 panel said that indeed Judge Bumb was correct, and they would not stay that part of the injunction. The next thing is the in-person interview requirements of character endorsers. Judge Bumb said that was not acceptable under the Second Amendment. This 2-1 panel agreed with Judge Bumb that preliminary injunction with respect to that is continuing. And the last thing is the insurance mandate for carrying guns. You had to have insurance under the law. Judge Bumb said that's unconstitutional. And then this 2-to-1 emergency panel by the Third Circuit Court of Appeals agreed with Judge Bumb, and that preliminary injunction continues with respect to that so-called insurance mandate. So again, there is some very good news in this 2-to-1 panel decision by 2 anti-gun judges and 1 favorable Second Amendment judge. It's not a victory. I'm not loving life in this context, but the good news is we did still win a bunch of stuff. The Third Circuit merit panel, we don't know who that's going to be. They're going to get another crack at all of this and have the opportunity to spend more time in thinking about it. And remember, the Third Circuit gave us the en banc victory, a big victory in the Range versus Garland dealing with nonviolent felons. That's a long, powerful decision in favor of the Second Amendment. And obviously, we're in the same court. So I still have hope and optimism that we're going to be okay in the Third Circuit Court of Appeals, which of course covers Delaware, Pennsylvania, and New Jersey, but only time will tell. So again, hope you learned a little bit something here today. Sorry I'm a couple days late on this, but I'll try to do better in the future. And again, don't forget to subscribe to the Four Boxes Diner, and we'll see you again here at the Four Boxes Diner.
Orders up. Table 2A.